Good morning and welcome to Employment Hour in 30. I'm John Scholes. My co-host, the guy with the knowledge, Lior Samfiru from the Samfiru Tumarkin Law Firm. Lots to get through today. We are going to educate you all this show, all year as a matter of fact, as to your employment rights, your severance, what it should be. I mean, hey, you spend 8 hours a day there, 5 days a week at least, so you should have some rights. You should have the knowledge about what you can do, how to protect yourself moving forward. Lots of stuff to get through today. We're going to talk about you having more seniority than you realize and what happens when your boss tells you to return to work early if you're on long-term disability. But a ton of things to get through. Moving forward, the phone number 1-855-821-5900, help@employmenthour.com through email as well. We'll plug those throughout the show so you can write them down and keep them with you. First, though, Lior, we start every show with the week that was, a look back at some current things that people and our viewers would be interested in. What's going on?
Well, John, a lot that's going on, actually. You know, it's at this time of year, it's very busy. We had a lot of calls, people that have either got the show here on TV or heard us on the radio, and they want to know more about their specific situation. I'm very happy about that. You know, I can only give so much information out on this show. I can get a lot more information out when you talk to me, you ask me the questions, I can help you with your personal situation. So if you're watching us right now, you have a workplace problem, maybe your boss did something to you, and you're not sure if that's right, give me a call. If you lost your job, definitely give me a call. If you have any problem at the workplace, you're mistreated, maybe you're being harassed, happens all the time, John, we've talked about this before. Don't just suffer, don't think that there's no options, there's always options. Give me a call, I'm here to help, and we'll talk about all the ways where people have a lot of rights where they may not even realize on the show. But to get us revved up here on the Employment Hour in 30, let me talk about a situation that came across my desk a few days ago. So I got a call from a gentleman who recently was diagnosed with a serious medical condition. Luckily, though, for him, there's treatment for this condition. He'd have to see a specialist, but for about 2 months, he'd have to go to see the specialist regularly, about 3 times a week, on a regular basis for 2 months, and the hope was that this was going to make him better. Sure. Well, he told his employer, and the reason he told his employer is because he would have needed some accommodation. Some days he may have to leave early to go to this specialist. Other days he may have to come in a bit late because it wasn't always at the same time. So he told his employer, I need you to be flexible with me. Give me that flexibility for the next couple of months. I'll still do my job as best I can, but I do have to get to that specialist to get better. Well, the employer had a difficult time with this. He said, well, you should do this on your own time. You shouldn't impact your work. We're paying you, so we don't want that. Well, he told them, but this is the time. These are the only times. I'm not happy about this, but the only time I can go is this. So that's what he did. Despite them protesting his employer, he went to the specialist, and he did sometimes have to come in late and leave early. Well, after about 3 weeks of this happening, his employer said, this is not working out. We're letting you go. You're supposed to be here 9 to 5. You're not here 9 to 5 every day, so we're going to let you go. He called me obviously very upset. He thought, you know, after 10 years of working for this company, that he deserved better. Well, again, guess what, John? He did deserve better, not just from an ethical standpoint, but from a legal standpoint. His employer had an obligation to accommodate him. That means giving him the flexibility that he needs to go to his doctor to get that treatment. The employer cannot decide, oh, this is too much, oh, we don't want to do this. It's not up to the employer. The law takes care of that. So if you're watching right now, I want you to understand, if you need accommodation because of a medical condition, for example, your employer has to give that to you. That may mean changing your job. That may mean giving you flexibility with your hours. That may mean allowing you sometimes to work from home. There's really no finite list of things. In this case, the employer didn't do that. So not only is this a wrongful dismissal, that's a human rights violation as well. It's a very wrong thing to do. I see this more often than I should be seeing this, and hopefully I can educate some people to know that if you are in that situation, you have rights.
Now, on the wrongful dismissal side of this particular case, he will get his full severance, but including, you mentioned a human rights violation, there's also potential damages as well, right?
Absolutely. Not only is he going to get the severance that he's owed because he was let go without severance. They said, well, you're not working, so we're not going to pay you severance. Nonsense. Of course he gets his severance. But because they failed to accommodate, because they breached the Human Rights Code, he could be owed, and he is owed, other compensation for violation of the Human Rights Code. So there's a number of heads of damages, if you will, that he's owed here. So I'm going to get him that. And I want our viewers to understand that if you're in that situation, the law is going to take care of you.
1-855-821-5900. That's the number to keep on. You get a hold of Lior's firm, or Lior for that matter. Email is help@employmenthour.com. Confidential, of course. We'll get to some a little later on the show. We've also, for the past almost 5 years now, taken a ton of calls on the radio shows that we do. And we'd like to get to the interesting ones, play them for you, and hopefully the viewers can glean something from this call. We'll get to one right now.
I was on PIP about 7-8 months ago. After 6 months, but I was warned by an email. Then after 6 months, they just let me go with 8-week severance. Just the office clerical job. About 10 years. Am I entitled for anything extra?
I think I know the answer already.
You do know the answer, and my hope is that our viewers know the answer. It's not right what happened here. First of all, let's talk about this performance improvement plan. The fact that you may be put on a performance improvement plan, well, first of all, it may not be legitimate. And the key here, if you're put on a performance improvement plan and you don't agree with it, say something.
Right.
Okay? Silence is the same as acceptance.
Yep.
You got it. So if your employer says you did these things wrong and that's not true, when you don't agree with that, say that. Say exactly. You don't have to be rude about it. You can say, here's what actually happened, or here's why I disagree with it. But even if it is legitimate, John, even if the performance improvement plan is legitimate, well, guess what? That doesn't mean that they can let you go for cause, even if your performance is lacking. I want our viewers to understand that even if you're not the best employee, it's still extremely difficult to terminate someone for cause. And in most cases, if the employer lets you go for cause for performance reasons, you still are entitled to your full severance because it's not a for-cause termination. Now, for this gentleman, let's run through this scenario. If I'm right, and in fact he is owed severance, so let's plug his details into the severance calculator. We'll talk about more of that in a second, and what he would actually be owed. So office clerk for 10 years, I don't know his age, but let's say he's in his 50s. Let's assume he's making, mid-level salary of $45,000. He was offered 8 weeks pay. Well, guess what? As the calculator says, he's actually owed 10 months pay.
Not 2 months.
Not 2 months, not 8 weeks. 10 months pay. So he was wrongfully dismissed. And I see this happen very often. Individuals that are put on a performance improvement plan, the employer lets them go with minimal severance and say, well, what do you want? We put you on a performance improvement plan. It doesn't work that way. Even if you are in a performance improvement plan, and even if it is legitimate, if the company lets you go, you get your severance.
And you mentioned, voicing your displeasure with the performance improvements plan. Those things, and everything else for that matter, should always be in writing, right?
Always in writing. John, what do I say? If it's not in writing,
It doesn't exist.
It does not exist, John. If you're going to voice your concerns, if you're going to object, or any important communication you're going to have with your employer, it has to be in writing. We live in the age of email and text messages. Guess what? It works perfectly well here. It doesn't have to be a formal letter on letterhead. Email works, but in writing, always.
Outside the radio shows, we do this for a half hour on the weekend, so people often after the show, viewers go, I got tons of questions, I want to ask you a question. You can do so at terminationquestions.com. I'm going to read one for an example, and I'll let you expand on this. Lior says, do you have a formula for people working under federal labor laws, like in a Crown corporation or federal government department? I know that the rules are different and provincial labor laws don't apply. I have a feeling I may be told to retire soon.
Right. Well, there's a number of things we need to unwrap here. First of all, and this is a very important question because we're going to have viewers that are federally regulated. Maybe you work at a bank, or you work for an airline or a railway company. So you may, or for a radio station, John, and you may be regulated federally. Well, guess what? Just because you're regulated federally, the same severance rules apply to you when it comes to your full entitlements. Now, your minimum entitlements may be different if you're regulated federally, but your full entitlements, what we call your common law entitlements, are the same. They're based on your age, your position, and the length of your employment. Right. So whether you work for, if you're a 5-year employee as a manager, 65, you're going to get the same severance, whether you're working for a federally or provincially regulated company. So many people think there's different rules and they don't get the same severance. They get less severance because they're federal. Wrong. You get the exact same amount.
Let me throw an employment scenario past you here, and we do these every week as well. Kurt has been working in the same job for 21 years, same company. Due to major depression, PTSD, he's been off work and on long-term disability. His permanent disability has been approved, but his employer sent a letter saying that they are ending his employment relationship in 2 weeks should Kurt offer to return to work in order to keep his job.
Well, it's a good point. Now, here's the thing. If, in fact, Kurt can come back to work, because he says that he's been given permanent disability. But if he can go back to work, I would absolutely tell his employer, yes, I can come back to work and I want to. Because at that point, if he is terminated, number one, it could be a human rights violation. You cannot let someone go because they're on a disability leave. So they could owe him human rights damages, and he'd also be owed his full severance. And if he's been there for 21 years, he could be looking at as much as 2 years' pay. Now, if he can't work legitimately, regardless of what he wants, he just physically can't, then the company can terminate employment. This is what we call a frustration of contract. Frustration of contract happens if you're unable to work anymore at all. The company can end the relationship with you, but they would have to pay you less severance. For him, depending on the size of the company, that could be as little as 29 weeks, potentially even less than that. So the question is, can he go back to work? If he can, he may have significant entitlements, both under the Human Rights Code and for severance. If he cannot go back to work, he may be owed less severance than that.
Who ultimately makes the call? Is it Kurt, or is it his doctor or his medical team?
His doctor makes the decision, ultimately. His doctor obviously is going to make that decision in consultation with him, with Kurt. But if his doctor says, yes, you're able to at least try to return back to work, he can tell that to his employer, and his employer has to take him back. So the doctor makes that determination. You always go to the doctor first. It's not up to you, the individual, and it's certainly not up to the company to decide whether you can or cannot work. And if your employer ever tries to put pressure on you to come back to work when you're not ready, that's wrong. As long as you have your doctor's support, they have to let you be off work as long as it needs, whether it's a week, a month, a year, or longer.
Your employer may put pressure, or they may start snooping around and asking questions they shouldn't. As far as prognosis, diagnosis, what are they allowed to ask for someone who's off?
Your employer often may try to ask questions and get information that they're not allowed to know. Well, what is your employer allowed to know? They're allowed to know, first of all, how long are you going to be off work? If there's any limitations that you have, you need accommodation. When are you going to be reevaluated? Information that gives them an idea about your return to work and their obligation to you. That's what we call prognosis. Diagnosis is very different. Your employer is not allowed to ask questions about what is the medical condition, what kind of specialist are you seeing, what kind of medication are you taking, is it contagious? None of that is something that the employer really is allowed to ask or allowed to know. You're well within your rights to say no to diagnosis questions. It's improper.
We'll take a short break. Emails help@employmenthour.com. You also have employmenthourtv.ca and 1-855-821-5900 anytime you want to get a hold of yours team. Still to come, coming back from medical leave, and there's nothing to come back to. There's no job. That and the severance pay calculator is on the way. Employment Hour in 30. Hang on.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back, Employment Hour in 30. We've talked about it. In fact, we talk about it every show. We're finding out exactly what your severance offer should be. There's a surefire way to do it. It's been operative for about 4 or 5 years. And I mean, literally hundreds of thousands of people have tried this. SeverancePayCalculator.com. Take it away, man.
Well, John, when people sometimes say hundreds of thousands, that's a figure of speech, but this is not a figure of speech. Literally hundreds of thousands. I think it's 400,000 plus have already used the severance calculator. So what is it if you're not familiar with it, or maybe you need a refresher? Well, the name says it all. If you need to know how much severance you're owed, and by the way, you do need to know that, then you go to severancepaycalculator.com. Again, severancepaycalculator.com. It's a tool that I created that allows anyone to find out exactly how much severance they're owed. Doesn't matter if you've worked for a year, for a month, for 25 years. Whatever it is, you can find out exactly how much you're owed. And spoiler alert, it's not a week's pay per year or 2 weeks pay per year. It's a lot more than that. So if you're staring at that severance letter right now, you had that uncomfortable meeting with HR and they told you today's your last day, you have that paper in front of you, please, please, please do yourself a favor. Go to severancepaycalculator.com right now. Find out how much you're owed, compare that with what they've offered you. And if it's not the same, if they've offered you less, you know what to do. You can contact me directly from the calculator. Or maybe you haven't lost your job. You're just curious, you want to know. Or you've spoken with your friend across the street and they lost their job. They're uncomfortable because they don't know what to do. Just tell them to go to severancepaycalculator.com, take the Severance Calculator Challenge. If you think you know how much you're owed, Go there anyway, find out the real number. I bet you anything it's more than you realize.
And it really takes about 30 seconds. There's a contact button on the bottom. I mean, if I can figure it out, pretty much anybody can figure it out at that point. Right?
If John can figure it out, then no problem.
Safe as kittens.
It takes seconds, John. It's so worth it.
Example, Karen used it, right? You got an example?
Yeah,
for us?
so let me run through an example. Someone that actually used the calculator, and I've changed the names to protect the innocent.
Sure.
But so Karen contacted us. She had worked for a company as a bookkeeper for 8 years. Now she was recently let go. Now they treated her as an independent contractor. So guess what? When they let her go, they didn't pay her any severance. She was 49 years old, making $46,000, and she used the calculator. So she got nothing after 8 years, 49, 46 years old. The calculator correctly told her that she's owed anywhere from 8 to 10 months of compensation. That's $30,000 to $38,000, John, that she's owed. Now, I am not giving you this example because it's a special or unique example. I'm giving you this example because it's a very common situation. I get submissions like this daily, many times a day. And by the way, you don't have to send this to me or submit it to me. You can just use this for your own information. But for someone like Karen, this is literally meaning tens of thousands of dollars using that calculator. There's nothing unusual there. So if you're looking at your severance package, guess what? It may actually be tens of thousands of dollars less than what it should be. SeverancePayCalculator.com.
Try it even if you don't need it. Phone number, by the way, if you want to get an assessment done live, you can do that. 1-855-821-5900. That'll put you in touch with Lior's team. Help@employmenthour.com through email. And we also take a ton of phone calls, as you know, like we did in the first part of the show, on our live radio show every week in the Employment Hour. Let's get to another one of those calls.
My wife is 60. She's going out on a surgery, so she's on medical leave. And then when she comes back, I think they're going to put her on EI because there's no job, apparently, for her to come back to. She worked at a company for 16 years. It sells. The franchisor has taken the franchise off her boss's hands. I just want to know, like, roughly, what would she be entitled to after working there for 16 years?
No, there you go.
Well, great question. Well, the first thing is if she's off right now and she's going to get better, it's going to be very difficult for her employer to say today, oh, we already know that you don't have a job to come back to 3, 4, 6 months later when you're ready to come back. How would they know that, John? It almost seems like they're going to let her go or put her on a layoff because she's off on a medical leave of absence. That's illegal. That's a human rights violation. But even that aside, John, the question is, well, what does she get? Well, let's plug that into our trusty severance calculator and see what happens. So she's in the sales roles, John, 16 years, age of 60. Let's assume her salary is $51,000. I just made up her number there. Well, someone in her situation would be owed right around 18 months' pay. So assuming a salary of $51,000, that's over $76,000. So she'd be owed about 18 months' pay. So I want to make it very clear here. The company can't say, well, we're just going to put you on the layoff for a while. That's still a termination. If you've been put on the layoff, quote unquote, that's a termination, or you can treat that as a termination. And in this case, my concern is that there's also potential human rights issues, but at a minimum, she's probably looking at an 18 months pay.
Again, SeverancePayCalculator.com. You'll want to do that on your own for an exercise. 1-855-821-5900. Lior, the number, anytime you want to call that. And emails, which we'll get to a little later in the show, help@employmenthour.com. We'll take a short break, and we'll tell you this. Chances are you might have, in fact, we almost guarantee you have more seniority than you think. More Employment Hour in 30s coming up. Hang on.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back, Employment Hour in 30. And as we mentioned before the break, we do a live radio show, have been for years, the Employment Hour. And each week we take a plethora, it's a word for the week, a plethora of phone calls on the show. We like to get the interesting ones and let you have a listen. And you'll comment on them, Lior. Here's another call.
Out of the blue, I was approached by my employer that I'd worked with for the last 4.5 years with totally change of our contract terms. He expected me to sign right away, and reducing my pay rate, the way it was structured, it was going to be substantially less. Am I entitled to any compensation? Like if I refuse, and he says, well, get lost, right? My average income would have been 55 to 75. I'm 63.
Is get lost a legal term?
That's a technical term, by the way. And by the way, I did notice the Three Amigos reference there a second ago. So let's talk about this seriously. And this comes back to this concept of constructive dismissal, John, that you and I have discussed on the show before. And to make it very clear, an employer does not have the right to change the terms of employment in a significant way. And in this case, if we're talking about changing to compensation, well, it doesn't get more significant than that. You know, compensation being probably one of the more important terms of employment that we have. And it doesn't always have to be, well, we're going to reduce your salary from $70,000 to $50,000. Oftentimes, it's a change to the structure. Maybe commissions decrease or base salary changes or the bonus goes away. So there's different types of changes. As long as it reduces your overall take-home pay, as long as you make less money because of these changes, that's otherwise in what I call an illegal change. Which means in this particular situation with this listener of ours that called us on a radio show, yeah, he is well within his rights to say no. Why would he say yes, in fact? And he doesn't have to accept a change like that. The problem with him accepting the change, and you know this, John, is if he accepts it, he wants to be that good soldier, he gives the employer arguably the right to do it again and again in the future. So he has a choice. He can accept this change and continue working, or he can treat his employment as being terminated, again, a constructive dismissal, and leave with his severance. Now, for the purpose of giving a full answer here, let's do an analysis about what that severance would be. Let's plug his information into our trusty severance calculator. So he's in a sales role, 4.5 years of employment, 63 years old. Let's assume salary of $70,000, whatever it is. Well, someone like in his situation, anywhere from 8 to 10 months pay, okay? 8 to 10 months pay. So that's $46,000 to $58,000 that he'd be owed if a constructive dismissal. So he has to think, do I want that 8 to 10 months pay, or would I rather stay with the lower paying job? That's his decision, but the law makes it clear you do not have to accept a significant change to the terms of your employment.
You know, it's funny, we talked about this for so many years about when there's change to the employment, and often this is the same when people first take a job, they looked at that contract. They may be thinking that year or the year ahead with 10% pay reduction, but it's the aggregate of 20 years.
Yeah.
That's what's you got to look long term.
You got to think about it. And if your employer is going to start messing around with your compensation, it may be better to leave, get your severance, and move on to a different job where you're going to have better stability. But you mentioned employment agreement. You know, one of the things an employer can do is, and some employers do this, believe it or not, they can stipulate in the employment agreement that we, the employer, have the right and the power to change your job compensation, or to change your salary down the road. What a horrible thing if you think about it, for you to sign an agreement that gives the employer the full discretion to reduce your pay. So that means today we felt like paying you 20% less, John, we're going to do it. So you want to be careful about signing employment agreements that give the employer that type of power. Bad idea. And if you're not sure what your employment agreement says, please give me a call.
And that's 1-855-821-5900, help@employmenthour.com. We mentioned that we're going to get into this as well. You have more seniority than you realize. We'll go through some talking points and you can expand on them. Number one, if you've been working as, quote, independent contractor. We love those.
You know, we touched on it very, very briefly on we talked about the calculator. So oftentimes, so many times, John, people think or believe that they're independent contractors, but the law really is going to decide that they're employees. So let's make it clear. You don't decide if you're an independent contractor. Your company doesn't decide if you're an independent contractor. The good thing is the law decides. The law takes care of that for us. So if you're calling yourself an independent contractor, but you have a regular job with regular hours, you are an employee. Doesn't matter how you pay your taxes, doesn't matter if you have your own company, doesn't matter if the company says that you're an independent contractor. And why is that important when it comes to seniority? Well, because if you really are an employee and the company lets you go, then all these years that you've worked there count as employment years. And that means you get your full severance. So I've had situations where someone worked as a quote-unquote independent contractor for 30 years, but they really are employees, so they were owed 24 months pay. So if you're an independent contractor, you probably are an employee in most cases, which means you have seniority, and which means you get severance.
You may have more seniority than you realize if you've been recruited from another company.
Yes, if you've been recruited from another company, so you're not looking to leave, that someone else comes to convince you to leave another company, they eventually convince you, and then guess what? After a while, it doesn't work out and they let you go. When in many situations, in that type of a scenario, the law may give you additional years of seniority to account for the time you had with the previous company. So you may have worked for a company for 10 years, were recruited away and worked for a new company for a year. Well, when it comes to termination, you may be an 11-year employee. So you may have a lot more seniority than you realize. It's what we call inducement. So definitely, if you lost your job after being recruited from another company, you have to get legal advice. You also have to pay attention to an employment agreement that you signed. So be very careful if you leave a secure job to take a job with no security, because it could end up not working out, and then we have to make sure that you get everything you're owed.
You know, this one fascinates me too, as far as possibly having more seniority than you realize. If there's a gap in service.
Yes, gaps in service can be interesting. A lot of people don't realize this, and here's how this works, John. Sometimes in situations where the gap in employment is not large in reference to the overall length of employment. So let's say I've been with this company for 20 years, but 2 years of that I work somewhere else in the meantime, in between, then the law may say that really we can consider all your years of employment when it comes to seniority and severance. So sometimes we can essentially disregard gaps. If you're working for a company and you left and they wanted you to come back, they essentially recognize your service. If not formally, then informally, you may have a lot more seniority than you realize. We had a question on the radio a few days ago, John, where someone that had worked for 5 years left and then came back for another 3 years. Well, they were considered 8 years of employment, 8 years of seniority. So you may have a lot more seniority than you realize, even if your employment with the company was not continuous.
It also may happen if your company is taken over by a new employer, right?
Yes, sale of a business.
Yep.
So when the general rule with the sale of a business is if you continue working with the buyer inherits your service. So on day one with the buyer, you've had all your service with the previous company. So if at some point the new company lets you go, when it comes to seniority and when it comes to your severance, you get credit for all your years from the previous company. So a lot of people get very worried about, well, what happens if I accept this job? Do I start afresh? What if they let me go? Am I going to get any severance? The answer is yes. Unless you sign away your seniority, unless you sign a document that says you agree to give up your previous seniority, then in those situations you automatically inherit the seniority, the company inherits it, and if you're let go, you're going to have full seniority recognized even with the previous company.
And our final point on this one for the week, when you may have more seniority than you realize if you're on a disability or maternity leave.
Right. The time that you spend on a disability leave or any maternity leave counts towards your seniority. You may have worked for a company for 1 year, been off on a disability leave for 2 years. Well, now you're still a 3-year employee, even though you haven't worked for the last 2 years. So time spent on a leave, maternity, parental, disability leave, counts towards your seniority, and when it comes to severance, that time has to be accounted for.
1-855-821-5900 for further questions, of course. Help at employmenthour.com. You can also go to employmenthourtv.ca, the website, to check out a little more. I'm going to throw this employment scenario at you. Ben posted comments on his Facebook account that were critical about his workplace, never a good idea, specifically where health and safety issues were concerned. A few days later, he was fired for what his employer called bashing the workplace using social media, quote unquote. Because he was fired for cause, no severance was provided. Is that right? Is that legal?
Well, I would want to obviously see what he said about his employer. If he made some honest, truthful comment, yeah, it's legitimate. I mean, I still don't think it's the greatest idea, but remember, it's so difficult to terminate for cause unless you were completely bashing them and being unreasonable and calling them names and saying lies, that it's not cause. So if you're saying some things about your employer may be unhappy, but that does not mean you can be let go for cause. You probably are still owed your full severance. This is because, John, as we said, it's not a question of whether or not what he did is right. You may be let go for cause, even if without cause, even if you've done things that are not right. It's difficult to terminate for cause. It's the death penalty. It's reserved for the worst offenders.
We'll take it for another week. Glad you were with us. Hope join us again next weekend. To get a hold of Lior, 1-855-821-5900. It is help at employmenthour.com. We talked about it, used it several times today. SeverancePayCalculator.com. Find out exactly what that severance pay should be. And online, of course, employmenthourtv.ca. Till next time, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.